The UNHCR submission is that the flight on 14 June to Rwanda should not proceed, and more generally removals to Rwanda under the agreement between the UK and Rwanda should be suspended. The reason for this position, most relevant to these interim relief proceedings, is the UNHCR's serious concerns about Rwanda's capacity to make fair refugee status determination decisions adequate to protect from indirect refoulement. In its written submissions, the UNHCR draws the court's attention to a number of relevant factual matters. Mr. Binsky highlights that the vast majority of the Rwandan government's decision-making on refugee claims has been of a prima facie kind, concerning objective circumstances in a limited number of nearby countries of origin, and that case-by-case determination is nascent. There is said to be only one eligibility officer in Rwanda assessing all such claims. Mr. Binsky also highlights that when the Secretary of State and the UNHCR met in Kigali in March 2022, the UNHCR was not informed that the UK government was contemplating a process of removing asylum seekers to Rwanda, and therefore did not elicit the UNHCR's views on this proposal. Further, the Secretary of State then omitted from the published policy documents concerns which the UNHCR had raised about the proposals in meetings held in the UK and Kigali in April 2022. The substance of those concerns are set out at paragraphs 14 and 15 of the UNHCR's written submissions before this court. Mr. Binsky also highlights that the UNHCR has subsequently become aware of decision letters issued by the Secretary of State which contained incorrect statements about the UNHCR's involvement in the agreement with Rwanda, its role in oversight, and claims that the UNHCR had not expressed substantial concerns. Addressing the first ground of appeal, Mr. Binsky reiterates its submissions made before the judge that the UNHCR warns that there is a real risk of indirect refoulement if asylum seekers are removed from the UK to Rwanda. The UNHCR has concerns about the fairness and capacity of the refugee status determination process, which cannot be rectified at speed. Mr. Binsky also submits that persons relocated to Rwanda may be at risk of detention and treatment not in accordance with international standards should they protest against their conditions after arrival. Having identified that there were serious issues to be tried, the judge went on to consider the balance of justice question. That is the critical question on which the present case turned. As we have said, in our view, the judge conducted that balancing exercise in a way that cannot be impugned by this court on appeal. We consider that on analysis, the principal ground of appeal before us is indeed ground 2. The starting point for his assessment was that the interim period would be relatively short, about 6 or 7 weeks, until around the end of July. He was right to take that view. We do not accept the submission that the judge was obliged to take into account the possibility of appeals and further delay after the judgment of the High Court has been given after the substantive hearing. The hypothesis for the appellant's case must be that they will succeed at the substantive hearing. On that basis, as the judge noted, the individual claimant would, on his own case, be entitled to be returned to the UK. If there were then an appeal, as the judge observed, it would be a matter for the appellate court to determine what the next steps should be. For example, whether any interim relief should be granted pending an appeal. Given, therefore, that the interim period would be relatively short, the judge was entitled to take the view that it was unlikely that the individual claimants before him would be improperly returned to another state by the Rwandan authorities in that time frame. To suggest otherwise is indeed, as the judge noted, speculative. Furthermore, in that context, the judge was entitled to give weight to the MOU and note verbal. They may not be legally enforceable, even as a matter of international law, but they are formal agreements between sovereign states. The UK will expect Rwanda to comply with them, and the Rwandan authorities will know that their conduct will be under scrutiny in the particular context of people who have been removed there by the UK pursuant to the arrangements between the two countries. The judge did not need to be sure, as has been submitted, that the MOU would be implemented. This was something to which he was entitled to give weight. And as Mr. Dunlop reminded us, questions of weight are not for this court on an appeal in cases such as this. We return to the fundamental point in this case, which turns on how the judge dealt with the balance of convenience. In our judgment, he conducted that balancing exercise properly. He did not err in principle in the approach which he took. He weighed all the relevant factors on each side of the balance. He reached a conclusion which he was reasonably entitled to reach on the material before him. This court cannot therefore interfere with that conclusion. And the final heading is conclusion. For the reasons we have given, this appeal is dismissed. Is there anything else?
My lords, my lady, with great diffidence, I have an application for permission to appeal.
Well, there you have it, Lord Justice Singh at the Court of Appeal refusing to grant that injunction halting Tuesday's planned deportation flight of migrants from the UK to Rwanda. The appeal has been dismissed.